Jai Hind everyone. I am Vishal Gupta from Ajay Kumar Garg Engineering College. Today we are going to discuss the topic named Companies Act 2013. It is part of third year subject, that is Constitution of India Law and Engineering of Abdul Kalam Technical University. So let's start with this topic. The Companies Act, it is an act of the Parliament of India on Indian company law which regulates incorporation of a company, responsibility of a company, directors, dissolution of a company. So here what is going on, that basically in India we know that there are various kind of business ownership. We have sole proprietorship, we are having partnership, and another kind of basically ownership is companies. So here our government, it basically realized that companies, they are comparatively bigger bodies than sole proprietors and partnership. So there should be a regulatory framework which should basically help to regulate the companies so that they do not try to take undue advantages. So here our parliament, what it did, it basically brought this Companies Act 2013. It basically replaced Companies Act 1956 and added new norms, new instruction, new laws in the law. So here what is going on, its main objective is to regulate incorporation of a company, that how a company will be started, what would be the requirements of it, and what are the necessary things which a company, which a promoter need to fulfill before starting a company. Beside this, responsibilities of a company, directors, and dissolution of a company. So responsibilities in terms of that, what is its responsibility towards its stakeholders, whether they are customers, whether they are shareholders, whether they are supplier. So towards them, what is the responsibility of a company? Beside this, the directors or the people who are taking decisions of a company. So what are their responsibilities as well towards a company? Then the dissolution of a company. So at the time of liquidation, this may take place in case if there is some big losses took place in a company and company borrowed some money from the market, and due to which it is because of the losses it was unable to repay those loans. So at that time this dissolution may take place, or there may be some other reasons depending upon the promoters what they feel. Sometimes they may also feel that they may use the money of this company in another business, so they may also think about dissolution of a company. So the 2013 Act is divided into 29 chapters containing 470 sections as against 658 sections in the Companies Act 1956 and has 7 schedules. However, currently there are only 484 sections in this act, and the act has replaced the Companies Act 1956 in a partial manner. So not in a fully manner. Whatever sections, whatever part we felt that Companies Act 1956 was having good, so we basically remained that part in this new act, that is Companies Act 2013, and after receiving the assent of the President of India. So we know that all bills, they are basically converted into a law when assent is given by our President. So the section 1 of the Companies Act 2013 came into force on 30th August 2013, and 98 different sections of the Companies Act came into force on 12th September 2013 with few changes, like earlier private companies, maximum number of members were 50 and now it will be 200. So earlier what used to happen, for a private company at max 50 members can participate, 50 members can be owner or shareholder of that company, but now this has been replaced and now 200 members they can start a private company. and a new term of one person company is included in this act, that will be a private company, and with only 98 sections of the acts notified, and a total of another 183 sections came into force from 1st April 2014. So here what is going on, that we found that firstly the number of people they have been increased in private company, and secondly a new concept of one person company, it was introduced through this act. Now the Ministry of Corporate Affairs therefore published a notification for exempting private companies from the ambit of various sections under the Companies Act, and the 2013 legislation has stipulation for increased responsibilities of corporate executives in IT sector, increasing India's safeguards against organized cybercrime by allowing CEOs and CTOs to be prosecuted in case of IT failure. So here what is going on, some legal restrictions they have been basically put on, especially on the IT sector, and the major reason is the cyber crime, because they may take place from outside our country, so they may affect India and its people's interest. So here the CEO and CTOs of such companies, they will be prosecuted at the time of IT failure. And Minister of Corporate Affairs and introduced the Companies Act Bill 2020, and it was passed by the Parliament in 2020. Now firstly, what is a company? So company is a legal entity established by a group of individuals to employ in and regulate a business firm. So here what is going on, that some people they basically realize that they are having a business. It may be at the partnership level as well, and people may think about converting that partnership into a company. So few people they basically realize that it's very much better that now they should start a business. So here what they are doing, they are basically starting a company, and the major benefit is that company is considered as a legal entity in the eyes of law. So a company may be coordinated in different ways for financial liability and tax purposes, relying upon the corporate law of its administration. So here what is going on, here we have to discuss this financial liability. Financial liability means that suppose that company it has taken some loans, so it is responsibility of that company to pay that loan, and beside this, in case if that company has made some profit, then company is also responsible to pay taxes. Now the line of a business concern in an enterprise is will normally ascertain which business structure it picks, for instance a partnership, a corporation or a proprietorship. In such a case, a company may be contemplated as a business kind, and hence companies can be classified either on the basis of liability of its core members or on the ground of the total number of members. And on the basis of the liability of its members, the companies can be categorized into two categories. First category is that company's liability by share. So in this scenario, what is going on? Its members, they are having liability which is restricted to the level of the nominal value of share. We know that shares in stock market, they are generally traded at premium. So here what is going on, that the people, the members, they are only liable up to the extent of nominal value of the shares, or the face value, that is generally in India is 1 rupees, 2 rupees, 5 rupees or 10 rupees. So if a shareholder has paid the complete amount of the shares, there is no liability on his side, and whatever may be the debts of the enterprise, he may not pay a single rupee from his private property. So this thing generally do not take place in unliability case, but here what is going on, that here the shareholders liability is limited to the extent of the nominal value of the shares. Now the Unlimited companies. So when there is no constraint on the liability of its shareholders, such a company is known as unlimited company. And when the company's property is insufficient, here the company's property is, in case if it has taken some loans and that company is unable to repay, so in case of insufficiency to pay off its arrears or debts, the private property of its shareholders can be used. So if we compare this with this case, here we saw that liability was only up to the level of the nominal value, but here in case if this company is unable to repay its loan, so in such cases what will happen? The shareholders' personal wealth will also be used to recover that debt. So to put it in other words, creditors can ask for their dues from their shareholders, and such enterprises are not to be found in India, though approved by Section 2 of the Companies Act. Now features. So firstly, it is considered as a separate legal entity, but in the case of proprietorship, in the case of partnership, we see that this concept does not exist in partnership and in sole proprietorship. But here if we talk about the company, that this case in actual exists. Here a company is considered as a separate legal entity or a independent corporate entity, and it simply means that it is independent of its members and shareholders. So like any other person, we know that two people are, if they are present, then both are considered as separate legal entity, both are considered as independent entities in the eyes of law. Similarly over here in the case of companies, we find that companies, they also get the same status of separate legal entity. Now nextly, the limited liability, which we have discussed, that it is up to the value of nominal, it is up to the nominal value of the shares. Next is it can own property separate from its members, and the property is vested with the company as it is a body corporate. So like we know that we people, we human being, we can purchase property. Similarly over here, a firm, a company can also have its own assets as well and may utilize for its betterment. Now the income of the members is different from the income of company. So in case if that company is making profit, if that company is making any kind of income, so it would be considered as a separate amount. It wouldn't be added in the members' income. Now perpetual succession. So the death of the members is not the death of the company until it is wound up. So here what is going on? Generally in small businesses, we feel that there is uncertainty, especially in the terms of its in terms of the life of the business. But here we are finding that in case if death of member or director or any person who is at a very responsible position, if that person dies, still what we find that that company wouldn't be dissolved. As it is a legal entity or a juristic person or an artificial person, it can sue and be sued. So we know that in case if any person does any kind of default in a company, so company can sue against it. And similarly, if company does anything wrong with any other party, then that party can also sue this company. The company enjoys rights and liabilities which are not that of the members of the company. Now these are different types of companies. First is the limited company. So it is limited by share or by guarantee. Second is unlimited. Third is government company, foreign company, private company and public company. Firstly, what is limited company? So in such companies, the liability is only the amount that remains unpaid on the shares. Secondly, limited by guarantee, not having a share capital. So in this type of company, the memorandum of association limits the members' liability, and it will be based on the undertaking that has been given in memorandum of association for their contribution in case of a winding up. So in case of a winding up, this basically must be written in MOA of a company that how the liabilities will be paid by members. Next is limited by guarantee having a share capital. So in such cases, the liability would be based on the memorandum of association towards the guaranteed amount, and the remaining would be from the unpaid sums of the shares held by the person concerned. Now the unlimited company, so there is no limit on the liability of the members. The liability in such cases would extend to the whole amount of the company's debt and liabilities, and here the members cannot be directly sued by the creditors. When the company is wound up, the official liquidators will call upon the members to discharge the liability, and the details of the number of members with which the company is registered and the amount of share capital has to be stated in the article of association. Now the government company, so here what is going on, when 51% or we may say more than 50% of the paid up share capital is held or is owned by government, whether it is a state government or central government, and the share can be held by the central government or state government, partly by central and partly by two or more government is also be considered, and such kind of companies will also come in government companies. And as the legal status of the company does not change by being a government company, there are no special privileges given to them. So here what is going on, that no doubt these are the government companies, but still what is going on, no any special leverages or privileges they are basically given to them. Now next is the foreign companies. Suppose there are people who started their company outside of India and they are also not Indians, but later on they feel that India is one of the best economy to invest, to get better returns or to get exponential returns. So in such cases what will happen, they may they are also eligible to start their company in our country as well. So a company incorporated outside India but having a place of business in India, and if it does not have a place of business in India but only has agents in India, it cannot be considered to be foreign company. So in case only if agents are present but that company is not present, so at that time it wouldn't be considered under foreign company. Now the private company, so a company that has a minimum of 2 persons and they have to subscribe to the memorandum of association and article of association. So here we know that minimum 2 person they can start a private company, and now earlier 50 members were allowed to start a private company, but now this limit has been extended to 200 members. So it should have a minimum paid up capital of 1 lakh or more as prescribed by the article, and the maximum number of members to be 50, but now it has been increased to 200. The rights to transfer the shares are restricted in the private companies. So in the public limited company, we know that shares they can be easily traded in stock market, they can be sold to any other party, but in private companies we find that it is not so easy to transfer shares to any new person. Beside this, it prohibits any invitation to the public to subscribe, and therefore it cannot issue a prospectus inviting the public to subscribe for any share in or debenture of the company. So we know that basically prospectus is generally used to basically borrow capital or borrow money or to sell part of its ownership or shares to common man. So here in case of private limited company, private limited companies are not eligible for this. It prohibits acceptance of deposits from persons other than its members, directors or their relatives. If two or more are holding one or more shares in a company jointly, they shall for the purpose of this definition be treated as a single member. So suppose two people, they join together and they basically purchased share of a company, then at that time these two people, they or their ownership would be considered under a single member. Besides this, as there is no public accountability like a public company, there is no rigorous surveillance, because actually this thing is very much required in public limited companies, because in such companies there is possibility of scams, there is possibility of insider trading, but in private limited companies such kind of cases do not take place. So the laws, the rules, they are a bit liberal in case of private limited company. Now next is exemption and privileges of a private company. So it can have a minimum of 2 members. It can commence business immediately after obtaining a certificate of incorporation. This is one of the major advantage, that just after receiving certificate of incorporation they can start their operations. Then it need not issue a prospectus or a statement in lieu of a prospectus. It can have a minimum of 2 directors, and it needs not hold a statutory meeting or file a statutory report with the registrar of company. Now public limited company. So a public company means a company which is not a private company and which has a minimum paid up capital of 5 lakh rupees or such higher paid up capital as may be prescribed. Secondly, which is a private company and is not a subsidiary of a company which is a private company, and it includes any company which is a public company with a paid up capital of less than 5 lakh, then it has to enhance its paid up capital as per the statutory requirements. Now incorporation of a company. So the person who conceives an idea of a company, decide and do the necessary work for the formation of a company are called the promoters of the company. So suppose a person, he thinks that I should start such kind of business, such kind of businesses are not present in India, and that business can do a lot. And sometimes we also see that people they are not starting businesses for making profit, but they are thinking that they should start a business for social work, for the benefit of common man. So such kind of things generally they come under the category of NGOs or non-governmental organization meant for social welfare. So here the promoters, they are the persons who decide on formation of the company, and the promoter of a company stand undoubtedly in a fiduciary position, though they are not the agent or a trustee of a company, and they are the ones who create and mold the company. So it is expected that that person should be in a fiduciary position, should be a trustworthy people, or and they may have to enter into pre-incorporation contracts which can be validated after the incorporation of the company for obtaining certificate of incorporation. Now promoters, so they can be remunerated for their services, but they have to enter into a contract before the incorporation of the company through a pre-incorporation of the company. So generally what we see, the promoter or the owner of that particular business, that particular company, in case if they are working on a regular basis in that company, then they are eligible to get the remuneration or the salaries for their services offered for that particular company, and they will usually act as nominee or act as the first director of the company. So the person who started this particular company, that would come under the category of nominee or the first director, and they enter into contracts after the incorporation and before the commencement of business, but they need not compulsorily participate in the formation of the company. Sometimes a few persons may only act as professionals who help the promoters on behalf of the company, like the solicitor, chartered accountants, etc., and get paid for their services. So suppose a person, he thinks that now I should go for a public company. So it is not so easy, because there are so many legal basically formalities which a company needs to basically do before going to public or before becoming a public company. So in such instance, what happens that promoter also needs some other people, some solicitors, some bankers, some chartered accountants, who will in actual help him, so that that company basically may bring prospectus into the company, into the market, and help to basically get that company shares sold in a market. So they are basically paid for their services, and the promoter is most of the case decide as to what is the type of a company to be formed. So what type of company a promoter wants to make, this is the major thing, and on the basis of that these decisions, they are basically taken. So in India, promoters generally secure the management of the company that is formed and have a controlling interest in the company's management. So generally, the person who is going to start that particular business, that person must be having the controlling stake or controlling interest in that particular business. So that is more than 50%. Because sometimes what we feel, what we see in market, that suppose a new company is started, new business is started, so a part of that is generally sold by that person to other people or to other venture capitalists, who basically help in basically a firm to get money for its further expansion and survival. Now promoters have the following liabilities under the Companies Act 1956. Firstly, they can be liable for non-compliance of the provision of the Act, because now the promoter is in actual the person who will get all the benefits, all the profits basically made by that company sooner or later. So it is expected from that person that that person would be liable in case of non-compliance of the provisions of this Act. Secondly, severe penalty may be imposed in case if that company is not following rules and regulations set by this Act. Thirdly, the court may suspend the promoter from taking part in the management of the company. This is a very serious clause in this Companies Act, that if it is found that a promoter is not working as per this Act, then that promoters will in actual lose the power of taking part in the management of the company. So that person would not remain eligible to be involved in the major decision making of that company. The next is the liable for any untrue statement in the prospectus to a person who has subscribed for any shares or debentures on faith of the prospectus. Prospectus is an important document of every public limited company, and it is expected that whatever is written in a prospectus, that is 100% true, and in case if it is untrue, then a serious action can be taken against the company, because a person, a new shareholder, is in actual reading that particular prospectus, and on the basis of that prospectus, that person is taking decision whether to invest or not to invest in that particular company. So the liabilities, these are to set aside the allotment of shares. Secondly, sued for damages, sued for compensation, and criminal proceedings. So it is a very strict, a very stringent basically Act, and definitely in our country it should be present. Now the requirements. Firstly, the application for the availability of name, that firstly suppose a person is going to start a company, and so that person will in actual basically need to be aware that that particular name is available or not. Secondly, the preparation of memorandum of association and article of association. Thirdly, selection and finalizing of MOA and AOA and its printing, stamping and signing. Nextly, the preparation of other necessary documents which will in actual help a company to be started as early as possible. And next is filling out the required documents for registration to obtain a certificate of incorporation and certificate of commencement of business. So that's all for today's topic. Thank you.